Be brought in your case, we step outside, give you distance until that time. Is Alan back there? No, sir. We have any of the three grades.
Branch is ready, about to go.
Well, Branch is going to be a hearing. I'm taking short on this first.
Okay, Miss Ray is getting changed out, and I've got to do, this is seniors, right? I've got to do senior junior too. So I'll be back in the next.
But I don't know, if we're just picking a status day.
You ready to have experience on that?
Yes.
Well, why don't we go ahead and pick a date on all three of the grades, and then we can bring out this grade, get her arranged just a moment, and we'll bring out the younger Mr. Gray for this bond. All right, Gerald, I'm assuming the discovery of this matter is rather voluminous, is that correct?
It is, Judge, but we have taken the first step. Everybody has agreed to protective orders on confidential items, and I've got those prepared and ready to present to the court if I may approach. Yes.
Yeah. You need to dress out?
I do.
All right, sign the check orders. All right. I mean, realistically, they got issues in Roane County as well. Has there been discussions about which jurisdiction is going to be going first?
Your Honor, I have talked to Bob Edwards, who's handling the matter in Roane County, and I think he and Mr. Roble have had some discussions, and I believe that Roane County is going to take priority and go first. We have a status date in Roane County on December the 18th, and so in talking with Mr. Roble, I think we would both suggest that we go out into January for status date here. I would hope on December 18th we might get a trial schedule at least in Roane County.
Well, I mean, right now we're just in limbo. We know that the Supreme Court has ordered that there's not going to be any trials until February. Who knows, if that's going to be extended or we just don't know yet. So I don't have a problem if everybody's in agreement setting it that last week of January to see what they are.
That's fine with the state.
What about that last Friday? I believe it's up to 29th. 29th of December.
I have a trip planned to try to get canceled. It hasn't been canceled yet. Could we go maybe to the February 5th instead?
February 5th, good for everybody?
Works for us.
All right, February 5th, their status on each of the three grades. And are we ready to bring out Ms. Gray for arraignment? She herself.
I'll speak to find out the report about my
Okay,
client.
yeah, you need your clients to go back to Roane County, so you can go on to the next. Can we move the hearing matter to the 4th instead of the 5th of February? Mr. Kirk's gone back into the dog. Okay. And Mr. Lanzon, you represent Mr. Gray Jr., correct?
That's right, that's fine.
Is the younger Mr. Gray dressed up, ready to come out?
I'm ready.
Gentlemen, do you have any interested parties who were informed previously that are interested in bond?
No, Judge.
Okay. Is he close, Ray, or should I go ahead and take it, Mr. Al?
I think he's close. That's just,
All right, Mr. Gray, have a seat there at council table, please. Mr. Lanzon, you are recognized on the bond.
Thank you, Your Honor, and I'll try to be as brief as possible. Your Honor, we filed a bond motion in this case, and if I can, I just forbid I'll go through the statutory requirements for setting a bond, and how they do and do not apply when applied. First and foremost, we talk about the defendant's length and residence in the community, a lifelong resident of Knoxville. Prior to this, being arrested and charged on. He was working for Jewelry TV. He worked there for 8 years. And but for being locked up, he'd still be at Jewelry TV today. Your Honor, he has a long-term partner who he lives with, has been living with, and has lived with even during the pendency of these allegations. Family ties and relationships. Clearly, this is the big issue in this case. He has the massive misfortune of being related to two very repugnant people who did a very repugnant thing. But I want to make very clear for the record, he is a son related to these people, and I have yet to hear one allegation that he participated, knew, or had anything to do with the death of these children.
Stop for a second. What is his bond rating?
I believe $500,000.
$500,000.
Yeah.
Okay, go ahead.
Your Honor, as it relates to the defendant's prior criminal record of appearance in court proceedings, there's absolutely no criminal history whatsoever. His reputation in the community, there's been no allegation of any alcohol abuse, substance abuse of any kind, no violence. As I said, prior to this allegation, he's known in the community as an upstanding citizen. Any fact indicating the defendant's ties to the community vary. Your Honor, he's not a flight risk. He has absolutely no financial capabilities right now whatsoever. Does not possess a passport. I don't know that he's even ever traveled outside the United States. So he is not a flight risk, which leads me to the ability of this community to maintain him. Your Honor, he is the perfect candidate for pretrial release. If this court wants to put him on a GPS monitor, I would encourage the court to do that and set this case out. This is going to be a long haul. And what I mean by that is my client is innocent and will stand on that throughout the pendency of these proceedings. We have an ongoing Roane County situation as it relates to the parents. That's going to take quite some time. As this court already indicated,
Is Mr. Gray charged in Roane County?
no, he is not. And so I know this court has some history of Roane County proceedings, and let me just say, quickness is not their forte. So that is going to take some time.
Officer General Johnson will be glad to hear that Mr. Cameron.
Well, they have a circuit, Your Honor, rather than meeting every day, so it's not a function of their due diligence, let me say
I
that.
agree on very closely. Go ahead.
Your Honor, and as it relates to the nature of the offense and the apparent probability of conviction, Your Honor, I don't know if the court is aware, but the state's position is a felony murder rule position. It is not that I'm aware that he actively participated in this at all. And so I have yet to hear any of that. I know that there have been multiple interviews done of his parents. They have accepted responsibility completely. Neither one of them has implicated my client in any way, shape, or form. And so I would just ask, Your Honor, that all of the Tennessee, the Title 40 statute, all of the factors relate in favor of my client and in favor of him being released on pretrial.
Okay. All right, gentlemen.
Judge, while it is correct that Mr. Gray has a little criminal history before these proceedings, Judge, in terms of just whether or not this bond is high enough to reasonably assure his appearance going forward, I think the $500,000 bond is appropriate in this case, and I would ask the court to keep it at $500,000 because obviously Mr. Gray is facing a number of extremely serious charges. The felony murder in and of itself would be enough to put him in prison for life on top of the other charges. So he's looking at a very lengthy prison sentence. He would have incentive based upon that alone to flee this jurisdiction. And so that's the reason why we asked that the bond stay exactly where it is for right now. Furthermore, the fact that he's a longtime resident of Knox County and that he has ties to Knox County, Judge, I don't think that should cut in his favor at all. His ties to Knox County are based upon this family who engaged in torturous behavior towards a number of adopted children that they had. And when Mr. Lanzon gets up here before the court and says, well, there's no direct tie, I'm here to tell you that there's going to be a lot of proof that there's a direct tie between this defendant and exactly what happened. There are going to be children, 2 living children that directly implicate him as being living there, being fully aware of what was going on and doing nothing to stop it whatsoever. He lived in the same house where also a child was found dead and buried in the backyard, where evidently Senior also planted a new tree. So the idea that he had no idea what was going on when there's people there that say that he did know what was going on and that a child was buried in his backyard is absolutely ridiculous, Judge. So that's just a couple of the facts that we think cut in our favor on this. The risk of conviction for Mr. Gray under those facts and under other facts, such as financial gain that he obtained through all of this by keeping quiet, by not doing anything about it, that's also present in this case, significant financial gain. So I would ask this court to consider just a couple of those facts.
You've got, as I understand it, there's a residence in Rowan County where the Rowan County authorities have alleged that there was aggravated child abuse as well as felony murder counts arising out of that residence.
That's correct.
Were all 3 of them living in that residence, or did at some point in time were all 3 of them living in the Knox County residence?
Judge, what we think the proof will show is that at one point between 2011, the latter part of 2011, all the way until June of 2016, Michael Gray Sr. and Shirley Gray lived in the house that was owned by Michael Gray Jr. They lived in the basement area with all of these adopted children, that they shared that home together. They all lived
Or here?
in Knox County, Judge, in the Halls house, and that was from the latter part of 2011 until June 2016. And then in June 2016, we think the proof will show that they then moved to Rowan County and resided in the 10-mile area from that point on until all of this came to light this year.
Okay.
Judge, just in terms of the whether or not he's has a passport, yes, I don't know whether or not he has a passport. To my knowledge, he's not. I don't know what his financial situation is, so I can't speak to that, Judge. But whether or not this bond is appropriate at this time, the state argues that it is certainly appropriate. The proof we plan to present in this case, Judge, we argue is going to be overwhelming against this defendant, and he has plenty of incentive to try and leave this jurisdiction. In terms of whether or not he's dangerous to the community, Judge, I would just ask the court to take into consideration the facts of this case. They're extremely, they're extremely pronounced. They're awful, frankly. We're talking about the death and the abuse of multiple very small children. So I think that shows that if you're willing to do something like that, Judge, you're certainly a very dangerous person. And I would ask the court to take that into consideration. This isn't just about the fact that he has the misfortune of being related to Michael Gray Sr. and Shirley Gray. He's directly involved in this. He was actively involved in it, Judge. It's not just a misfortune of being related. He is part and parcel with his parents, and that's the reason why he sits over here.
You get the last word.
Thank you, Your Honor. I think one's ability to create a salacious and repugnant headline has nothing to do with one's bond. We can all agree that everything that's alleged is awful. But the biggest point that the state just conceded was these people left, and these people meaning his parents, left his house in 2016. What has my client done from 2016 until now? Absolutely nothing but being an upstanding citizen. And he did not participate in the killings of these children. And
Wasn't there a child's body buried in the yard of his home?
he didn't bury that body.
Did he know it was there?
Absolutely not. And there will be no facts ever come to light that someone can say that. None. And so from 2016 until now, he hasn't done anything, just like before, prior to 2011, when these allegations arise. He has a thorough history of being an upstanding citizen. And so again, and as the facts will come out, these were completely separate living quarters. It wasn't like they were sharing a kitchen, they were sharing a bathroom, and no one is going to say anything to the contrary. Someone's ability to say, well, he should have known, there's no way he didn't know, is very different than direct evidence that implicates him in participating in these crimes. The general just conceded, he doesn't have that. He must have known, he should have known. That's different. And that's why he's charged under the felony murder rule, instead of actually killing these two children. He didn't do that. And because of that, when this court, as difficult a position as this court is in, the statute is what the statute is. It's very clear. And every one of the factors, other than a salacious and repugnant headline, break towards my client. He should be on pretrial supervision on a GPS monitor and back in the community, and that's just the way it should be. That's what the statute calls for.
Judge, just respectfully, could have known, should have known. There's going to be witnesses that say that he saw two children in cages in the basement of this house, that he saw them, that he was down there, that he was fully aware this was going on, that they were being locked in cages, being locked in a closet. That's not could have known, should have known. He knew. He was part of this.
Well, here's what we're gonna do today. I don't know nothing about this case, feel comfortable assessing the bond. I'm gonna hold the motion in abeyance, I'm gonna leave the bond where it is. At some point in time, if it lands on, if you feel like it's prudent, to develop some of the case, bring it back to court's attention, I'll consider it again, but, I mean, he's $500,000 for a felony murder indictment is just not unreasonable. He's looking at 51 calendar years on just felony murder counts that he's convicted before he needs to parole for it. So I'm not going to adjust the bond today, but I will hold the motion open in abeyance until such time as we want to go on further.
I guess, Your Honor, my question is, which factors in the bond statute is the court relying on?
Well, what I'm looking at is the likelihood of conviction, this thing I'm focused most upon, and the fact that the seriousness of the offense here, he's looking at spending the rest of his life in prison if he's convicted, and his reasonable likelihood to appear. I can't get away from the fact that the state is telling me that they have direct proof that he's involved in this, and they also have proof that at least one dead body was found on this property. I'm not adjusting the bond, but I'm not. All right, I'll see you back on the 4th of February, sir.
Thank you, Judge.
All right, Mr. Allen, if you would come around and have a city council vote, please. All right, we are before the 4th day in State Tennessee versus Brian Allen on for a motion to trial. Mr. Gully, on behalf of Mr. Allen, has filed a motion to continue this hearing. And then Mr. Allen has filed a number of pro se motions. Among those, he's requesting that he represent himself. But we can find Mr. Gully, where are we?
When I heard Your Honor speak this morning about the pro se motions, that was the first I had heard of any of those, so no, I haven't spoken with Mr. Allen about those. I also wanted to mention to the court that in addition to the motion that I filed to continue